Hi everyone, my name is Alec Davis, founder of MediatorAcademy.com, home of the passionate mediator. You know what we do on here, we interview the very best mediators and thought leaders from right around the world. This is the place for us to learn about new opportunities in our field, as well as how to overcome some of the challenges and dilemmas of life as a mediator, so that we can ultimately learn, grow and improve our effectiveness. Alright, restorative justice, I think, is a strand of mediation that doesn't get a lot of coverage, and yet from what I read, it can make a real impact on people's lives. So in this interview today, I'll be learning more about restorative justice, the practice, the principles, the benefits, and how you can get involved if you're interested. Now, my guest today is a criminologist and PhD student studying restorative justice at the University of Leeds School of Law, where he also lectures on the subject as well. He's conducted research for a number of organisations, including Restorative Solutions, the Restorative Justice Council, Search for Common Ground, and the United Nations Office of Disarmament Affairs. He's trained as a restorative justice practitioner and is the founder of the Community of Restorative Researches. It's a real pleasure to welcome Ian Marder onto Mediator Academy. Ian, a warm welcome.
Thank you very much. Very glad to be here.
Ian, what is restorative justice?
Okay, so restorative justice is an umbrella term. It's used to refer both to a set of principles and a set of processes which are underpinned by those principles, which I typically tend to refer to as restorative practices,
Okay.
but which can also be referred to as restorative justice, restorative processes, and restorative approaches.
Okay.
So some of these terms, like restorative approaches, you would tend to use if it were being used in the workplace or in schools. But my personal focus is on the use of restorative justice in the criminal justice process.
Okay.
So I tend to talk about it in terms of victims and offenders, but really what we're talking about is people who have caused harm and people who have been harmed.
Okay, so what's the underlying philosophy then, or the core principles?
Yeah. So it's basically, Brunel de Paoli, an academic at Leuven, says that restorative justice is a normative discourse on how justice should be done in a democratic state. So what she's saying is that democracies are underpinned by a number of values around things like social justice, human rights, and equality of opportunity. But what we might see as traditional criminal justice processes don't necessarily reflect those values. So they see our justice process as focusing on retribution at the expense of the needs and interests of those most closely affected by crime. So you might see restorative justice as being diametrically opposed to retributive justice in a number of ways. While our criminal justice process asks things like, what law was broken, who broke it, and what punishment do they deserve, restorative justice asks, who has been harmed, what are their needs, what obligations arise as a result of the harm being done, and what is the appropriate process to involve stakeholders in an effort to address the causes of what happened and to put things right. So the principles that underpin these processes can be split into those that relate to the process itself and those that relate to the outcomes.
Okay.
So in terms of the process, you basically want to identify parties with a stake in the offense and empower them so they can be included in deliberation and decision-making processes. So that's stakeholder inclusion. That's one of the key principles. This has to be voluntary.
Okay.
So voluntariness is another key principle.
Right.
It's also about an approach to crime that's flexible enough to be responsive to the needs and interests of the stakeholders and increase the likelihood of their needs and interests being satisfied.
Okay.
It also says, essentially, that our emphasis should be on participation, communication, relationships, and negotiate agreement.
Right.
I mean, these principles aren't exhaustive. This is just, a lot of people are undecided about which ones should go on the list, but I've kind of just put together broadly my list.
Yeah.
In terms of the principles that relate to outcomes, basically what you're trying to achieve is repairing the harm done by crime, reconciling the relationships broken or affected by crime, and reintegrating those affected by crime back into society. So really it's about repairing the harm that was done.
Yeah.
So if you imagine that you have people start out on an equal playing field, and then someone harms someone else, so that person comes down here. In the traditional justice process, the idea would be to impose a proportionate amount of harm on this person to bring them down here, thereby leveling things out.
Got you.
But what restorative justice says is that it's this person's responsibility, and society's more broadly, to help bring that person back up to gear.
Very interesting.
So the idea is it's kind of meant to be a more positive approach to crime and conflict.
Yeah, okay. So, I mean, where did it all begin? Where did it all start?
Yeah, so, I mean, one thing that a lot of scholars in this field note is that these are not necessarily new ideas, and a lot of them can be found in ancient legal systems like Ireland and Mesopotamia, whereby most penalties were around restitution, compensation, stuff like that.
Yeah.
But also indigenous practices in North America and New Zealand and places like that, where they didn't have a distinction between criminal and civil law. So it wasn't that sometimes you harm a person and it's that person's responsibility to sue you to get it back, and then sometimes you harm a person and the state takes over and, imposes punishment on you. It was just that they had conflicts between persons, which they knew had to be solved because they lived in very tight-knit communities, right? But the modern reemergence of restorative justice came about for a couple of reasons. Firstly, it's a direct critique of the Anglo-American justice process, particularly in places like New Zealand and Australia, where indigenous groups felt that the justice process wasn't culturally responsive. But also, it's commonly seen as coming from Ontario, which is where I'm from, where there was a strong Mennonite presence in the 70s, who basically wanted a more humane way of doing justice. But also it's about the victims movement, who felt that the needs and interests of victims were being ignored by justice processes.
Yeah.
So, I mean, the main author on this is this guy, Nils Christie, who wrote a really good article in the 70s called Conflicts as Property. And he basically sees crime as a conflict between individuals, and then that conflict, which is a property of the individuals, is stolen by the state, by justice agencies and by professionals. And from then on, it's the state and the professionals, rather than those most closely involved, the stakeholders, who decide what is important and what should happen.
Okay. So it sounds like then there are some assumptions embedded in the restorative practice, the restorative justice process, that you can rehabilitate an offender, and they can make a positive contribution to society, and it's their responsibility to then make amends for what they've done, rather than punishing them. I'm digressing here, but when you were talking,
no, it's okay.
I was thinking about how I resolve conflicts between my children. And you start off wanting one child to apologize to the other for whatever they did, but then you're coercing them into that apology, because if you don't say sorry, then rather than wanting them to do it, out of the generosity of their own heart. And I'm not quite sure where I'm going here, but it sounds to me that the aspect of voluntariness, the principle of voluntariness, is that one hopes that the offender would come to the table with some sense of kind of compassion, a generosity of spirit, to wanting to repair the situation, to make amends. Part of that outcome then is that they, from the victim's perspective, their faith in humanity is marginally restored. So that's got to be a positive thing. I've gone off on a bit. Something that you said sparked a thought in me, but I can't remember what it is.
No, it's really interesting because I think you identified a couple of important points there. You've got this idea in criminal justice now, you have the passive offender, where something is done to them. Whereas in restorative justice, it's about having an active offender, where they have obligations to put right the harm that was done. But it's also about having like an active society. And John Braithwaite talked about this idea that restorative justice is a very democratic thing. And if you're widening the circle, then you're getting everyone involved, and it's everyone's responsibility, really, because crime is a product of social condition.
Yeah, so at the heart of it is also this notion of accountability as well.
Yes.
Facing up to taking responsibility for your behaviours and the intentional or unintentional consequences of those behaviours, and holding yourself accountable.
And it's who are you being made accountable to? Because in the criminal justice process, it's the crown against you. You're being held accountable to the state in abstract, kind of as a representative of the community almost.
Yeah.
Whereas in restorative justice, you're being held accountable directly to the person that you've harmed.
Yeah. So are there particular crimes, particular cases that restorative justice is better suited to, seems to have more productive outcomes or better results than others?
Well, first of all, the evidence is mixed. So there's a lot of studies which suggest that it's not that good, not that effective in terms of reoffending for cases of drink driving where there is no victim. So if you've been caught drink driving, you have to do something like this. Some of the evidence shows it's not that effective, although more recent studies have shown that maybe it is a little bit effective.
So how would it work? Sorry, how would it work if you're caught drink driving? Who are you sitting across the table with?
Well, I mean, these would be sort of victim empathy, victim awareness stuff. You might have surrogate victims in that situation.
I see.
I mean, there have been a number of studies done on its use with minor offences and serious offences. There was one study from Australia on its use with sexual assault, which showed that it was really quite cathartic for victims, especially in cases where, an offense is random, but you blame yourself. So burglary, it can be quite good as well.
Yeah.
Because in burglary, people think that they've been targeted, or they worry that they've been targeted, they worry that they're to blame, and just to be told that it was random is very much a weight off people's shoulders.
I see.
So, I mean, you've got to think that there's multiple aims here.
Yeah.
So even if its use doesn't impact on reoffending, if it's cathartic for the victim, or there have also been studies that suggest that it's quite good for reducing post-traumatic stress symptoms. So especially things like fear. Research that I did in the Northeast with victims who had been through restorative practices following burglary, and these are all people who the offender had been sent to jail, and they used a restorative practice in the jail with the victims. And they said things like, when in their heads they built this person up to be towering over them, huge and scary, and then they meet them and it's just a kid.
Yeah.
And that does, as you say, it can restore people's faith in humanity a little bit, make them less suspicious of people, and just generally help them to move on and be less scared from the incident.
Yeah.
In terms of evidence around victim satisfaction, that's probably where the most positive evidence is.
Yeah.
There was one major study in the UK. So it is difficult to get really good evidence because it's difficult to get control groups. So one study in the UK that was funded by the Home Office and conducted by Joanna Chaplin and others at the University of Sheffield, they did have a control group insofar as they offered it to a number of people, and then of those that said yes, they only gave it to half of them.
Yeah.
So that's quite important because some studies have shown, 80% less reoffending, absolutely huge numbers, but you've got to take into account the idea that those who have said yes to doing it voluntarily might already have been less likely to reoffend anyway.
Indeed.
So what this study showed was around 14% lower reoffending, which doesn't sound like that much, but is quite significant.
It is significant.
With some of the other interventions and how they perform. 14% is quite significant, and the overwhelming majority of cases that were in the study were of quite serious crimes. Crown court, burglary, aggravated assault, very, very, what would typically be considered quite serious crimes, persistent offenders. Yeah,
Okay.
and also that study, I believe, showed 85% victim satisfaction.
Yeah.
Which is in excess of double what you would find if someone had just been through the court process.
Yeah. Fascinating. Really, really fascinating. So tell me a little bit about the process and how does it work?
Okay. So that depends on how it's being used, at what stage of the justice process we're talking about.
Yeah.
So, for example, you could use it at any stage of the justice process, in theory.
Yeah.
So you could use it instead of someone being arrested. You could do it after someone's arrested, but instead of them being charged. After they are being charged, but instead of them being prosecuted. or you could use it also, legislation just was passed in England and Wales to allow judges to defer sentencing. So they've been convicted, but they haven't been sentenced yet during the sentencing to allow it to take place at that stage. You could also have it as part of the sentence, or you could have it, once someone has finished their sentence.
Yeah.
So the process will be different at different times. And the guidelines that are typically followed or typically spoken of are the Association of Chief Police Officer guidelines, which basically say that you've got 3 levels.
Yeah.
You've got level 1, which would be on the spot. So you can imagine a situation where a young child steals a chocolate bar from a shop.
Yeah.
It's their first offense. They get caught, and rather than arresting them, if everyone agrees, the cop takes them to the store, and they have a discussion with the storekeeper or something like that, where all of this takes place.
Wow.
And when I say all of this, what I'm talking about is, first of all, you have a series of questions which are meant to address the harm that was done.
Mm-hmm.
So everyone has to talk about who was affected and how they were affected. And then secondly, you have collective decision making on the outcomes. So that should be common to any restorative practice.
Right.
Level 1 being on the spot.
Yeah.
Level 2 and level 3 would be what they call formal restorative conference or formal restorative practice.
Right.
Whereby you would get everyone together, much like a mediation.
Yeah.
So, I mean, I wouldn't say it's a type of mediation. I would say it's a type of ADR.
Yeah, okay.
And you could certainly have mediations that adhere to restorative principles.
Right.
And in fact, one of the main practices used is called victim-offender mediation.
Okay.
But more typically, you'd have restorative conferences. So you might have the facilitator, who's essentially the mediator,
Yeah.
and then one or more victim or offender, and you could have the supporters of either of those people. So you might, if the offender is a kid, you might have their parents.
Yeah.
If the victim is an adult, you might have their spouse or adult child or something like that, or a friend. And then you might also have volunteers from the community.
Uh-huh.
That's not particularly common in some restorative practices. In other restorative practices, such as referral order panels, which is mandatory for judges to give referral orders to under 18s at their first time they've gone to court if they pled guilty and if it's not an extremely serious offense.
Yeah.
And there you would have community volunteers, what they call panel members, who also are engaged in this discussion.
Got you. Okay. All right. So you've got sort of tier 1, tier 2 and tier 3 involve restorative justice practitioners.
Conferencing, right? Yeah.
Conferencing.
So just to clarify, tier 2 and 3, the difference would be that tier 3 would be a particularly complex case or a particularly serious case.
Okay.
So the idea of breaking it down like that is just that you would require additional training to facilitate a tier 3 restorative practice.
Okay. So let's say it's been offered to a victim and an offender.
Mm-hmm.
Or is that how it's done, or would the victim request it, or is it not?
Yeah, I mean, it totally depends on the situation.
Yeah.
I mean, in England and Wales, practice is very fragmented.
Yeah.
So it happens in different ways in different parts of the country. Even within a part of the country, it might happen in different ways. And again, that depends on the different stage of the justice process. So at the minute, they've got this idea of, on one hand, you can have offender-led restorative practices where the offender asks for it first, or on the other hand, you could have victim-led restorative practices. And to me, it doesn't really matter.
Yeah.
It's just about, to me, everyone is equally important in this situation.
Yeah. How easy is it then to access those sorts of resources? How widespread is the service in the United Kingdom, say? Yeah,
so again, it depends on different parts where you are in the United Kingdom.
Yeah.
So I don't know too much about Scotland. I know that in Northern Ireland, there is fairly comprehensive capacity to deliver this stuff because they actually have a youth conferencing service. So they have a professional, essentially a justice agency, which handles all of these cases.
Wow.
In England and Wales, on the other hand, it totally depends on the area that you're in.
Yeah.
Because a few years ago, you could only do this in some places. There's this idea of moral entrepreneurs, which is basically where someone finds it, likes it, and implements it in their area. So kind of the first one in modern times is Charles Pollard of Thames Valley Police, who went to Australia or New Zealand, I can't recall which, but he saw people doing it, and he very much liked it, so he implemented it across Thames Valley.
Yeah.
So this is what you call a postcode lottery, where basically in some places there's no capacity, in some places there is capacity.
Got you.
More recently, there has been significant growth in capacity because police and crime commissioners have just been given money to invest in it. So in a lot of places, that money has gone to the police, if they have a history of being facilitators themselves, with its own interesting set of implications. In some places, that goes to partnerships.
Yeah.
It's like in Gloucestershire, Northamptonshire, and Cambridgeshire, they're setting up partnerships, or partnerships are already in place.
Yeah.
In some places, so if you look at Durham as an example, in some parts of Durham, the police lead on delivery, whereas in Darlington, there's volunteer-led delivery.
Right.
So you have what's called a neighbourhood justice panel, of which there are several dozen now across the UK, across England and Wales, and that's basically where police or someone else refer cases on to this group of volunteers who deliver the cases themselves.
Yeah. So I'm curious as to the how far developed it is in Northern Ireland. Is that's no coincidence, right? Given the histories there.
Well, quite. I mean, it was basically, the situation was that in 1997 they had a chance to redo their justice system in quite a radical way, and there's a number of implications of that. One of which was that their policing ombudsman is far more independent than in other parts of the UK. That's quite an interesting example. Yeah. But yes, also they were able to set up this system, and actually they have legislation in Northern Ireland which says that judges, I think, are compelled to refer cases to restorative justice at the pre-sentence stage, apart from in the most serious cases. Yeah. And then you have the restorative practice take place if everyone agrees to it. You have to also, it's not just if everyone agrees, like you have to have a trained facilitator sign off on the idea that it's safe. Yeah. Because you definitely couldn't do it in a case where it wouldn't be safe. Yeah. And then what happens is that the outcome agreement is given back to the judge, and they can sign off on that as a sentence. Although they also have the power to say, no, I'm going to give an alternative sentence. Yeah.
Okay, that's interesting. So I want to come back to the process itself. So you talked about tier 1, where the law enforcement officer would bring the two parties together. There'd be a series of questions and then sort of collective decision making about the outcome, right? If we looked at sort of the tier 2 example, where you had a restorative practitioner, facilitating the discussion, the meeting. Break the meeting down for me into the stages. What would happen? What would happen now? What's the process up to the point of that collective decision making?
Okay, so really, in a level 2 practice, in a formal restorative conference, you would want at least 90 or 95% of the work to take place prior to it. I'm sure it's the same in mediation, all forms of ADR. It's that preparation is essential. So especially in a more complex case, you would have the facilitator having, first of all, doing a risk assessment, but also having a number of meetings with every single person who's going to participate, in which they try and work out, they don't want to be surprised. Yeah. They want to know exactly what people are going to say, more or less, exactly what's going to happen. They want to be able to understand the likely dynamics between the participants, because one problem might be, for example, that if you have a child as the offender, and then their parents might talk over them or interrupt them or do any number of things that the facilitator needs to be aware is going to happen beforehand in order to try and prevent it from happening.
Yeah. Well, I just want to pause for a moment. Yeah. A risk assessment. So what would be involved in that? What would you be looking for? How do you evaluate the risk?
Yeah. Well, I mean, like any risk assessment, it's very subjective. Yeah. I mean, what you're looking for is there a chance of harm to any party, basically? Yeah. And if there is, it's maybe worth discontinuing the process.
And we're not talking physical harm. Well, we might be, but
well, it could be. I mean, primarily it'd be emotional or psychological. So I mean, if the victim, just isn't up to it, for example, then they shouldn't be. Obviously, they can't be coerced into participating. Or there might be cases where the offender has agreed to participate, but maybe they're not. It's clear indication they're not going to take it seriously. That can be quite devastating for victims. So you'd want to stop it in that situation.
Got you. Okay. All right. Sorry. Carry on.
Okay, so in terms of the process,
Yeah.
you would basically have everyone in the circle has to say why they're there, what their relationship is with the incident.
Uh-huh.
Okay? And then you would have these series of what are called the restorative questions. And that would be what happened from your perspective, how has it affected you, who else do you think has been affected, stuff like that. It's meant to be, a quote, addressing the harm.
Yeah.
And then once that's gone around, it might go around a couple of times. There might be some debate. Although typically, or in almost all cases, the offender is required to plead guilty prior to this. So you have to have the offender accepting responsibility for the incident.
Okay.
Although that gets more complicated when it's used, of course, with non-crime incidents, or even with criminal cases. You might have quite often that they're both offenders and they're both victims in reality.
Yeah.
Or with non-crime situations like a community dispute, there is dispute over the facts of the case, and they have to deal with that.
Yeah.
But yeah, and then you would move on to designing an outcome agreement.
Yeah.
Basically, where everyone would get a chance to say what they think the outcome should be, and then the facilitator has to try and put something together. That ideally, in theory, you're supposed to put it down on paper, and everyone's supposed to sign it, and that's it.
I mean, just give me an idea of an outcome agreement. What are the sorts of outcomes that one would expect or experience?
Yeah. That again depends on the stage of the process at which you're doing it. Quite often, what victims want is to have their pain acknowledged and to have what they call symbolic reparation or an apology.
Okay.
And for a lot, it's actually, people be quite surprised how many people accept that as basically that's what they wanted. You might also have compensation. If someone's broken your window, they might have to pay it back.
Yeah.
Or you could have a situation where, especially if it was a kid and they do something, criminal damage at the house of some old people, they might, help them with the gardening or something. It really does depend, because equally, if you use it at the post-sentence stage, there might not be that much that the offender could do.
Yeah.
So it might just be assurances that they're never going to do it again.
Yeah.
It might also be stuff relating to interventions for the offender.
Yeah.
So, for example, if one thing that they need is drug treatment, one person in the group might insist that drug treatment is put on this list.
Yeah.
Which is quite interesting for a couple of reasons. Firstly, because there isn't the capacity everywhere in the UK to deliver good quality drug treatment.
Yeah.
So you have the problem of, you might have stuff in this that actually can't be delivered, which can be a problem in some places.
Yeah.
And the second thing is around this issue, or this thing called defiance theory, which is the idea that people are much more likely to comply to something if they feel like they have been involved in the decision making and they've agreed to it, than if not.
Yeah.
So there was some evidence from Northern Ireland which suggested that for things like drug treatment, offenders were much more likely to comply if it was decided through a restorative practice than if the judge had imposed it on them.
Well, that comes back to that notion of accountability. Someone making a free and informed choice to take responsibility for themselves and their actions.
Absolutely.
Yeah. Okay, that's very interesting. Very interesting indeed. So how does someone get involved? Who gets involved in this? What are their motivations? And what's the training involved in becoming a restorative justice practitioner?
So, quite often it is the justice agencies that deliver practices themselves.
Okay.
So, police, probation, or prison officers. There are also some non-state actors, like victim support in some areas have contracts to deliver restorative practices. Other non-state, for example, there's a social enterprise called Remedy in Yorkshire that delivers a lot of stuff in South Yorkshire, and I believe they just got the contract for North Yorkshire. But what is increasingly happening is that justice agencies are recruiting volunteers from the community to be facilitators.
Okay.
So it might be worth looking for neighborhood justice panels in your area. Sometimes they're called neighborhood resolution panels, community justice panels, any number of different ways of calling them. Even some, and those would be sort of So, for example, in Darlington,
Yeah.
it's run by the council.
Right.
Whereas in Bradford, I believe it's run in a partnership with victim support and some other justice agencies.
Yeah. Yeah.
But also, individual justice agencies are also in the process of recruiting volunteers. So, for example, where I live, the HMP Leeds prison, that is recruiting volunteers for delivery as well.
Yeah.
So there are chances to get involved. In terms of training, whoever recruits you will either deliver or commission training in. Typically, the training is quite short, in my view.
Okay.
Maybe 3 days. But in some places, they deliver much longer, perhaps much better training.
Yeah.
For example, in Darlington Neighborhood Justice Panel, they've set up their own training process, which takes a number of weeks.
Yeah. Because I would imagine, someone. I'm just thinking about the risk assessment you talked about earlier. To what extent would I need some sort of training, a real good understanding of, I don't know, some of the psychological phenomenons that might be alive in that sort of conversation, to be able to know to intervene, or to decide, hold on a second, this isn't going in a good direction. And I'm just thinking, I did one community mediation a while back now, and it was just between a couple of neighbours, and it wasn't overtly. There wasn't, I didn't feel like things were getting out of control at all, but there was just something going on in the room that I couldn't put my finger on between the two parties that led me to stop the mediation. I said, I have some concerns, but I couldn't articulate what they were. There was something going on in the interaction. I don't know if it was sort of a transference or on my part, or whether there was something. And I just left. I stopped the mediation, and then I sort of left. I was left feeling, wow, there was. I don't think I was at the edge of my sort of threshold of knowledge, experience to be able to manage that in a different way. Or maybe I sat down with my supervisor and we concluded that actually I did manage it well because I stopped the mediation. So, but yeah, I'm thinking about the level of training and development for somebody involved in this, and being very, very important and rigorous, just to avoid any potential ramifications.
You're absolutely right. I think that quite often the training is maybe not comprehensive enough. In a lot of places they use a script. So facilitators have a restorative script which has these questions on. And anecdotally, people say it works very, very well. And people who do use it say that they don't really have to deviate from it, and that usually it all kind of flows fairly well. Personally, I think there is scope for additional training on the psychology of conflict, certainly. Everything that Ken Cloak talks about, that's all stuff that I think people should know. Also, nonviolent communication, I think, is something people could be trained in this field. But absolutely, you have basically, the reality is that the justice agencies have very, very tight budgets.
Yeah.
Most of them have been cut by 20 or 30% or even more in real terms, or even more than that in real terms.
Yeah.
And this might be one of the reasons why they're moving towards volunteer recruitment.
Yeah.
Is that they're basically out of money.
Yeah.
Fortunately.
So what where do you see the potential in restorative practices?
What do you mean?
Where do you see it heading, and where do you see there's great potential in changing attitudes, changing behaviour in communities? You're clearly passionate about this, incredibly knowledgeable about this. What are your hopes and aspirations?
Yeah, I guess I would want everyone to be offered it, I think would be a good idea. It's not always appropriate, and there's certainly, in my view, it can't replace courts and the criminal justice process on account of the fact that it can't be used to determine guilt. That's one reason we still need the courts, and also because some people require the protection that the court offers, quite simply. So it certainly can't happen in every case. I think that everyone should be offered it. And there should be the capacity to deliver it safely and effectively for everyone who wants it. I also think there's a lot of capacity for it to be used in schools, with young people generally. In community disputes, it's increasingly being used by housing associations.
Right.
Have to deal with what they would call sort of ASB incidents. Antisocial behavior, I should say. Also, there is a lot of scope for its use in post-conflict societies. The principles can be applied to what they call transitional justice. And this is exactly what happened in South Africa with the Truth and Reconciliation Commission, whereby a lot of people wanted to prosecute the offenders, who in this case were people who committed crimes against humanity against the black population and dissidents. And what Mandela and other people said was, actually, we have other priorities, which is reconciliation and truth-telling. And that's been used. Those principles have been applied to more or less of an extent in Northern Ireland as well, particularly by non-state actors who are doing a lot of very good work in the communities there. A lot of good reconciliation work. Also in Morocco, there was some use of these principles in the transitional justice process, particularly in the truth-telling aspect. But no, at the minute, international criminal justice is mainly of the adversarial type, which is about focusing on prosecution. So I think there's a lot of scope in that situation, and even pre-conflict, for these sorts of principles to be applied in order to prevent or reduce the harm that's done.
It's interesting. I interviewed Richard Susskind recently, and he talks about. He's hugely passionate about online dispute resolution, and he talks about, rather than putting an ambulance at the bottom of a cliff, that we should just put a fence at the top of the cliff. Rather than that sort of adversarial dealing with the problem once it's happened, what preventative measures can we introduce into our justice systems and our justice processes to stop people falling off or jumping off or pushing others off, metaphorically speaking?
I certainly think there's a lot more scope in almost every aspect of government in the UK, at least, and in other countries, to be more proactive and less reactive. But the problem with that is it requires investment in the near term in order to achieve long-term objectives. And unfortunately, the government here and justice agencies and everyone, it's very short-termist.
It also requires, I think, just a change in mindset, a change in attitude, a change in philosophy. You talked about the sort of philosophical underpinnings of restorative practice and how it rubs up against the more sort of punitive philosophies of our justice process.
Absolutely. One of the most famous authors in this field is a guy called Howard Zehr, who's a prof at Eastern Mennonite University in Pennsylvania. And his book from the early 90s, which has been one of the most influential in this field, was called Changing Lenses. And it's basically this exact idea that you've just talked about. It's the idea that in many ways, although there is some debate around this, and I'm not entirely convinced, but retributive justice and restorative justice are to some extent diametrically opposed. And it really requires a change in lenses. And a change in the way that you see things. And this is what is quite interesting about the use of restorative justice in criminal justice processes and by the justice agencies, is that lens change has not necessarily happened. So what you have is a massive gap between theory and practice. You have what might be called restorative justice being co-opted by existing rationales. So you have the rationales of managerialism, which is that you want an efficient public sector, treat it like a business, sort of go through as many things as possible. And then you also have the punitive approach. And so what you would have, I talked about before when I was talking about, the police might do this, probation might do that. These are ideal types,
Yeah.
right? But in reality, it can be far, far different to that. And actually, the way that restorative practices are being used in some parts of England and Wales, it does have the possibility of negatively impacting on due process and on human rights of the offender in particular.
Yeah.
Because you might have a situation where offenders are put under pressure to plead guilty in order to participate in this, which, they wouldn't have necessarily had a chance to talk to a lawyer.
Yeah.
Or they might have got off if they'd gone to the court through court process, but they're put under pressure to plead guilty for exactly something you mentioned earlier, is this idea of voluntariness.
Yeah.
Well, but if it's, do this or you get prosecuted, that's not really much of a choice.
Yeah. Yeah.
So it's quite interesting. They call that sword of Damocles, whereby you have this threat of prosecution hanging over you, so you're more likely to get involved in some alternative.
Yeah.
But that can be very problematic, because another problem is that obviously participation is voluntary, but also the outcome agreement is voluntary.
Yeah.
And facilitators are not supposed to make suggestions as to what should be in there.
Yeah.
So you could have a situation, and my belief is that this probably happens fairly often.
Yeah.
And there is some evidence to support the idea that this happens.
Yeah.
Even though facilitators know they're not supposed to make suggestions, they, not necessarily maliciously, they say, oh, what about this? What about this? What about this?
Yeah.
And everyone just says yes because of the authority of, say, if it's a police officer. So there's a lot of interesting things around. There's a lot of difficulties in implementing these principles in anywhere near a pure form in a criminal justice process, which broadly does not adhere to those principles. So it's very coercive. It's very much about punishment. And how do you get the two together?
Very, very, very interesting. I mean, just listening to you talking now, I was thinking of the struggles the mediation field in the UK is having in the tensions between evaluation, facilitation, and everywhere in between. And to what extent does a mediator that evaluates or makes some suggestions interfere with the notion of self-determination? Unwittingly, with no malice intended, but because of who they are, how one of the parties might identify them as someone in a position of authority, and therefore defer to that piece of advice.
Yes, quite right.
When
I think that's quite significant in restorative justice, when it's done by justice agencies or part of the criminal justice process, certainly.
Yeah, and then then you've got in parallel to what you just said there, if the mediator happens to be a lawyer or a senior barrister or a judge with that experience, and despite their best endeavours to remain impartial, or as Ken Cloak says, omnipartial, they can't not influence the process. That is very interesting, and a debate that will, I'm sure, continue to roll on, and one that I'm hoping that we're going to have, burrow into a lot on Mediator Academy in the coming months and years. So Ian, someone wanting to find out more about restorative justice, wanting to get involved, where's the best place for them to start? Bearing in mind, some people watching this are going to be based in America, Australia, Romania, Cambodia, all over the place.
Yeah. I mean, I think the approach to take would be to just Google restorative justice and then your area, and just see what's going on in your area, because there are a lot of places where it's not really used. There was actually just a very interesting document published for free on the web by a Georgian university whose name I can't recall. It's one of the Georgian university, as in Georgia, USA, has like a center for dispute resolution. And actually, that document outline, which maybe we could post below, the interview after, that document outlines all the state legislation and state policy in the U.S., which includes restorative justice. If you're over here, if you're over in Europe, it's difficult to say. I mean, I would say Google restorative justice in your area. If you're in the UK, there's the Restorative Justice Council, which is a very, very good resource if you're looking to be trained. Yeah, I would say, Google is your oyster,
Yeah,
basically.
Google is your oyster. Listen, Ian, by the way, if people want to, reach out to you, find out a bit more about the work that you're doing, just say hello, say thank you. What's the best way of contacting you?
Yeah, that would be absolutely fine. I mean, you can email me on i.marder@leeds.ac.uk.
Okay.
And you could also, if you would like, I have this thing, the Community of Restorative Researchers,
Okay.
which is meant to be a research network. But I mean, I'm very keen for it to be interdisciplinary, interprofession, and international. So we have practitioners, we have prosecutors, judges, and teachers, everything from every part of the angle.
Uh-huh.
Everyone is welcome. You can find that on Facebook or LinkedIn. And please, join and become part of the discussion.
Wonderful. Well, I'll post that underneath as well so people can click through to that.
Okay, great. Thank you very much.
Ian, I've thoroughly enjoyed this. It's been really...
As have I.
It's been a real sort of education. I really appreciate it. I've been trying for months and months and months to interview someone on this subject. And I'm just really glad that our paths have crossed. And I'm sure people watching this now are going to be satiated after listening to you talk so authoritatively and just eloquently on the subject. Thank you very much for your time.
Thank you very much.